It's time now for the All Things Legal Show. Your host of the show, an attorney with over 20 years' experience practicing personal injury, a graduate of UC Berkeley, Pepperdine Law School, and a partner in the law firm of Ashton and Price. Here's Craig Ashton.
All right, welcome, value listeners. This is Craig Ashton. The show is All Things Legal. Personal injury attorneys distilling topical events into the legal essence. I'm joined by Edward Allen Shady.
Always good to be here.
And ultimately, if you haven't listened to the show, we are attorneys by trade, curious by nature. Let me break down the stories for you so you can determine whether or not you want to spend the next hour of your existence engaged in this experience. All right, so Kyle Shanahan, the coach of the San Francisco 49ers, had a mysterious auto accident, ultimately so significant that I think he fractured an orbital bone, fractured some ribs, ultimately broke his nose, it looks like, has clear signs of symptoms of a concussion. And it was a little bit nebulous as to what occurred. And I saw that before we'll talk about him admitting to being at fault. It was at the corner of Hamilton and Alma streets in Palo Alto. So I just took a quick look at it to see if I could reconstruct what occurred. And Alma is a main thoroughfare. Hamilton is an intersection, and Hamilton dead ends into Alma. Alma is one of those streets, one of the old school ones, where there's no dedicated left turn signal.
Okay.
So it's basically you yield to oncoming traffic on the green to make sure that it's safe. So I'm not sure if what happened is that he made a left-hand turn in front of oncoming traffic, failed to yield. He claims that he dropped his phone. He wasn't on the phone. It doesn't matter for negligence sake. I mean, if you're on the phone or you drop your phone, if you go into oncoming traffic, clearly there was a significant impact because when you have such a significant impact with the airbags deploying and you break your ribs and you break your hand, that's a heavy impact. So ultimately, we'll walk you through that and how that works. And speaking of injury claims within a sporting setting, we've got the anthropomorphic Dinger, which is a cat for the River Cats, which is essentially affiliated with the San Francisco Giants AAA team, sharing the field with Stomper, which is an anthropomorphic elephant. And thank goodness for Alec Thomas, who used to play for the Diamondbacks and I think is now on the Dodgers, essentially trying to get back into the big leagues, playing for their AAA affiliate.
Got dinged.
He walks out of the dugout, and here comes Dinger, man. This 7-foot-tall anthropomorphic cat probably can't see too well because the cat can't see through his cat suit, and going probably 15 miles an hour on one of those electric scooters, and boom, Alex Thomas comes out of the dugout and gets taken out. So that is clearly, you don't assume the risk of that. And I mean, Alec, if you're listening and you can't play baseball again, we can make a pretty strong argument that you might be entitled to like $100 million.
So, his performance that day indicated that he probably suffered and can't play baseball at 0 for 4.
0 for 4, yeah. And apparently he fell over the railing the day before because I threw out the first pitch of the Red Sox game yesterday. And so, you get to go down into the field and through the tunnel and, out in the field. And they were telling me, I was bringing up the story about Dinger, but because it was the A's versus the Red Sox, Stomper is their elephantine mascot. So ultimately, they were talking about that guy was having a bad week because he's playing Major League Baseball, Diamondbacks. Now he's on AAA. He's at some stadium he's never been to before. In Sacramento, and boom, falls off a railing apparently the day before and then gets taken out by the mascot. So we'll walk you through. There's a lot of legal issues. Assumption of the risk will not apply, and negligence, and basically long-term diminution in earning capacity based upon perhaps injuries that did not manifest, and maybe the symptoms came up later, and diagnostic tests will tell all. All right. Then we've got trust but verify. Wow. At a vulnerability trust exercise that was mandated by essentially Netflix, this guy opened up, as was required, and talked about using ketamine, and ultimately he had a kind of a history of drinking and using profanity on the job, and he claims that he got fired as a result of being forced to open up, and he should have a right to privacy during these trust exercises, and being fired essentially for opening up about his ketamine use, where he got fired.
That's ironic.
Yeah, I know. So we'll talk about that because that's just, you're on one of those retreats and they say, okay, well, tell us what's going on with you, Dave. Yeah, guess I've had a tough time, or at least, I like to drink, so I'm take a lot of ketamine, and woo, that's too much information there.
My $1 million salary is out the window.
Yeah, $1.1 million. And essentially the attorney said for the firing attorney, I think with Netflix said, quote, the ketamine therapy issue is factored into the termination. So, wow, that's a tough one, because if you're forced to basically open up at these therapy sessions, as a part of a mandated company vulnerability trust exercise, then wow, you showed some vulnerability and you trusted them not to get fired, and boom, that backfired. All right. All right, our gas prices.
Backfire on the fire, huh?
Our gas price is bumming you out. All right, California's going to pay you to buy your first EV. So essentially, there's a $270 million pot. And if you buy a car that's headquartered in California, so Rivian and Lucid, I can tell you right now, you can get a used Lucid. I paid a exorbitant amount for a car with a supercar, 1,000 horsepower, 0 to 60 in 2.6 seconds. I got massaging chairs. It's got 450 miles of range. It's an amazing car, made in the United States, engineered in the United States. It's manufactured in Arizona. They're headquartered in the Bay Area. If you buy one of their vehicles, you can get it probably used once, $180,000 brand new. You can probably get, when the lease return 3 years, get it for $50,000. And you will get a $1,750 rebate, cash on the hood, paid to you by California. So if you want to take a look at these EVs, I can tell you, they're 80% of the people that buy EVs never go back. I haven't had a combustion engine car for 9 years. And I had a Turbo Carrera Porsche convertible. And same color as, famous, basically 60s star. It was cool, man. A cool vehicle, super sexy. But when I got a Tesla Model X, ludicrous, it's faster. I could put the poodles in the back seat and, fit 6 people in it, and it's faster than the Porsche Turbo Carrera. So the idea is that these cars, the engineering, 80% of the people who get EV don't go back. And I can tell you, I'm one of them. And I've had now 5 different EVs.
Yeah, you've had quite a few. I don't understand why people are upset about the price of gasoline. If you've looked at the price of jet fuel for my private jet, it's insane what I have to pay to get that thing filled up.
All right, so we'll talk about that in the new program, and essentially using the general welfare power of the state of California to encourage basically EVs, which it could cost us, actually, because people will stop paying gas tax, right? Because right now, I go back and forth to San Francisco on the weekends. I have my primary home's in Folsom. I have a place in Telegraph Hill. And it's been 4 freaking years, man, where they're still basically redoing the Yellow Causeway and Highway 80. Man, my brother, lived in Hong Kong, Shanghai, Beijing, and I used to fly into Kai Tak, and they put a whole new airport in. Within 2 years, put 3 bridges in, and they finished that off in like 6 months. And meanwhile, 4 years later, in the 4th largest economy in the world, on a flat piece of highway that's already been built, it's still being built.
Well, you remember when they had the Northridge quake that Jaeger Construction came in and they had a $100,000 a day bonus to finish early. So they calculated all that in, worked 24 hours a day, 7 days a week, and then hired everybody in to get it. And they made a couple extra $1 million because they came in early and did it all. So you just give them a little incentive there on the highway, Craig. If I take my jet fuel cost and divert it over there, it'll be done in no time. Yeah,
the thing is the reason I bring that up is A, I'm frustrated, and B, basically there's a gasoline tax which is supposed to go into fixing the roads. So if people,
but you're not paying it.
I know, but what I'm
saying,
so
don't complain.
Right, I know, yeah. Dang it, man. You caught me on that one. I got to go back. So, but the point is that if you encourage EVs, where's the tax going to come from?
Well, I think as an EV, you have to pay more for registration, so they kind of pick it up there over a regular car.
That is true.
So they get you one way or the other.
One way or another. I'm going to find you. I think that's Blondie, man. Mm-hmm. All right, so San Francisco threatens Apple, Google with legal action over false nude apps. They're called Nudify apps. There are 55 apps on Google Play and 47 apps on the Apple Store where you can basically take a picture of somebody, unassuming, put them in a nude, and then basically put it on social media, online, etc. Can harass, basically, you can use it to extort people. So San Francisco DA said, cease and desist. You're essentially processing payments for unlawful images to Google and to at the Apple Store. I think that's something that needs to be done. And then AI Judge Judy, this is what you want to wait for, because I type in, or I basically paste in 3 stories about Florida man in flagrante delicto doing stupid things and ask the AI Judge Judy on Claude Anthropic to basically comment. And it's funny, topical, and it's insightful. All right, stay with us. When we come back, we'll talk about Kyle Shanahan and then Dinger taking out basically one of the players for the Dodgers AAA. Stay with us. Injured and you're considering an LA law firm looking to charge you 45% to 50% in attorney's fees? That's overcharging. Ashton & Price has been around for over 25 years, and I can tell you no matter how complicated your injury case, you should never be charged 45% or 50% in attorney's fees ever. Direct, experience, unrelenting, and honest local representation matters. It's called Home Court Advantage for a reason. Ashton & Price serious local attorneys for serious people with serious injuries. So for the best local advice, don't think twice. Call Ashton & Price.
What happens when the direct nephew of George Washington matches legal wits with the most prominent shady attorney on the planet? I'll tell you, the All Things Legal Show. Decades of legal expertise distilling the latest sports and celebrity legal battles, the Constitution, AI, and the 1,000 ways Florida man flaunts the law while in flagrante. In the immortal words of the Princess Brides Vicini, Thocrates, Plato, morons. Join Craig Ashton and Edward Shady on Spotify, TuneIn, Pandora, and Apple Podcasts, and listen to the All Things Legal Show anytime. You've been served.
26 miles across the sea, Santa Catalina is a-waiting for me. Santa Catalina, the island of romance, romance, romance.
All right, we are back. I think that was a tribute to Edward Allen Shady, who was a state lifeguard at Huntington Beach, right?
Yeah, but that's Catalina. I actually got attacked by a shark off Catalina diving one time.
Really? That was before you were attorney, obviously.
Yeah.
Because now they give you professional courtesy. Speaking of that, I'm swimming Alcatraz August 8th, coming up in a couple weeks. And throughout the first pitch at the Red Sox game, had clients, Michelle and Kent, came to the game. I could see them there. And Michelle clearly is an A's fan. Talking about Catfish Hunter and Vita Blue, and she bringing up all the greats when I was growing up. When I was growing up, I went to grade school at St. Matthew's Episcopal Day School, and there was only like 5 people or 6 people in my class. You know, you're wearing a tie and going to church every day, and basically it's in the choir and that thing. So Tim Haller was my classmate, and his father was Tom Haller, who played catcher for the Giants. So ultimately, I'm a Giants fan, because you can't go against Tim, even though the A's were like the good team. They were winning. The Giants were terrible, like Tito Fuentes. I just remember going, man, this is probably giving me a forecast into what my life's going to be like graduating from Cal. So hopefully this year Cal football is going to be good, but essentially I have learned not to basically attach any emotion to sporting event outcomes. And as a result, I'm happy if somebody wins, that team that I like, and I'm not unhappy if they lose, and I wish them the best. And they don't care if I'm having a bad day, and I don't care if they're having a bad day.
I'm just glad college football's showing back up.
Yeah, right. All right, so let's go ahead and break down some stories here that are outside the field of kind of what we do for a living, especially the EV issues and the Google and the Apple letter from the San Francisco district attorney, cease and desist regarding the Nudify apps. These are kind of a little bit in our wheelhouse, but definitely topical. 49ers Kyle Shanahan accepts blame for car crash, says he swerved when phone fell. So San Francisco 49ers head coach Kyle Shanahan said Tuesday, just a couple days ago, he was at fault in the Palo Alto crash on July 14th, in which he was seriously injured, and the other driver, 24-year-old woman, suffered minor injuries. So you never really know about minor injuries. I mean, because initially you may not have obvious ones like he had, which was basically he needed 40 stitches above his eye. I mean, he's bleeding.
And 3 broken ribs and a broken left hand. That was a bad accident.
Broken ribs are just super painful. I broke my ribs surfing more than once. And, I was in Costa Rica when I did it. And first of all, you don't want to be around anybody funny. And second of all, you don't want to have a cough. I mean, it's really, or basically a cold. Sneezing's brutal, but there's no treatment for it. And if you remember, 49ers, their quarterback ultimately played, I think, in the Super Bowl with fractured ribs, just with a flak jacket on. And ultimately, there's no real treatment for broken ribs, but they're really, really painful. So in terms of serious injury for the other party, you're not seriously injured. If your symptoms reveal the harm later, so maybe afterwards the adrenaline's pumping, you got the norepinephrine, you're not feeling a whole lot. It's kind of like if you go for a run and 2 days later you go, whoa. After the run you're feeling great, and then 2 days later you're going, whoa, I can barely walk.
Yeah.
Yeah, I'm having a similar experience right now because I'm training for Alcatraz and swam at the aquatic center, and I was out there for about 45 minutes. It's really cool to swim out in the bay and look at the Golden Gate Bridge, and basically I'm sighting towards a Ferris wheel, and it's beautiful, the Bay Bridge. But 2 days later, all of a sudden I go, whoa, I'm pretty sore. My neck's sore. I feel like I have whiplash. So the point is that you don't manifest usually the symptoms right away. And so the person who says that they were not seriously injured, they could develop numbness or tingling or burning, associated with discogenic injury, or maybe notice that they have a problem with their shoulder that they didn't notice, and it turns out they have a torn rotator cuff. So there's certain things that may be less obvious than bleeding from your forehead, like Kyle Shanahan was, needing 40 stitches. I mean, 40 stitches is a lot.
That's a tremendous amount of stitches. But apparently he's very proud of his plastic surgeon and showed the guys a picture before and after, and can hardly notice it. But the one I always like is when a client shows up, because I went to the emergency room, the doctor assured me I didn't break any bones, it was simply soft tissue. I go, well, you do realize that everything other than teeth and bones are soft tissues in the human body. So if you took an ice pick and stabbed the doctor in the heart and never touched a rib, it would be a soft tissue injury, but it'd be dead nonetheless. And it's those injuries that end NFL careers, MLB careers, NBA careers, not a broken bone.
Yeah, Steve Young was the guy with the fractured ribs, and then Aaron Rodgers, he had a soft tissue injury.
Yeah, Achilles.
Basically Achilles. And right now I'm listening to the Iliad as read by Derek Jacobi.
Achilles actually had an Achilles soft tissue injury.
Yeah, right. But the point is that, you can see how serious that injury was, because he had a guaranteed $75 million contract, and the Jets had to pay him for 4 plays, and basically no receptions, I think.
Yeah.
And, because the soft tissue injury, as it turned out after the MRI, it was very serious, and ultimately he missed a whole year. And they had to pay him guaranteed contract. So you can see how serious it is. But in this case, I think Kyle Shanahan did the right thing. So police reports come out with what's called a face sheet. So we can tell the person listed first on the face sheet, usually the one that's found at fault. And so if you don't have the rest of the police report, if you see that, we use it and we get it early so we know the other party's name, address, and also insurance information. Because it's very important to start the process early like that to get all the people that you need to alert to the damages into the system, and they need to be aware of you as the case moves forward. So in this particular case, Kyle Shanahan found out that the other party was at least initially being cited at fault. So he did the right thing.
Yeah, he stepped forward.
Yeah, because, there's going to be ways to prove this. There's video. There's going to be the event data recorder on the car. There's going to be his statements to the police officer, et cetera. And so he said when he saw that, he goes, look, I hit her. I don't know why it was reported that way. In other words, finding her at fault. The police report doesn't say that. I was going 20 miles an hour. I was not on my phone, but I dropped my phone, and it was stuck between my seat. It was on my lap, and it slid off, and I went down to look for it, took my eyes off the road for 2 seconds, 1,000. That's a lot, 1,000. And as I was coming up, the airbag hit my face and broke my nose, and then the visor really gashed me. So bottom line is, from a legal perspective, taking responsibility like that is definitely not in your interest because you don't have to say anything. But to be a good citizen and basically take responsibility for your actions when you know that you're at fault, there is nothing wrong with that.
Yeah, and he has insurance. I mean, if I was at fault with an accident, so I got plenty of insurance, I'd immediately say, it's all my fault, pay them everything. They don't deserve to be injured because of something that I did, not on purpose. He didn't do this on purpose. And at 20 miles an hour, that's about 30 feet per second, and her vehicle's coming in the opposite direction, let's say at the same closing speed, if not more. So you're going 60 miles an hour and you hit each other. It's a micro fraction of a second, usually 15 thousandths of a second for the entire accident with a connection between the cars. And you end up with these types of injuries. This poor young lady probably woke up sore as could be 2 days later.
Yeah, and he's saying that he's got headaches and fatigue. He's got
Concussion.
brain fog, and he basically, quote again from Kyle Shanahan, I was going 20 miles an hour. I was not on my phone. He says, it's not that lights are bothering me in terms of, the way he's responding to the concussion. It looks like it right now, but it's more just taking stuff in. Noises bother me when 2 people talk at me at once. The music out there at practice is killing me, but my symptoms are so much better. So the idea is that when it comes to concussions, they'll do a CAT scan to determine whether or not you have a subdural hematoma or something obvious, right? But beyond that, a CAT scan is not going to tell you anything nuanced. You can do a quantitative electroencephalogram, which is a QEEG, which is basically new technology based upon the ability to process information much more quickly with these large language models and new computing power. You can take a look at the 4 lobes of the brain to see how they're communicating in terms of the brain waves and determine if the brainwave communication, essentially sequencing, is not normal. And it's a better way to kind of objectify. So he may want to do that, but usually it's just time. There's no do 3 Sudokus and a couple long math problems and you'll be better. I mean, there's not really any therapy you can do. It just basically takes time for it to correct. But the fact that he took responsibility, I think that's the right move.
Thumbs up.
The insurance company will say, don't do that. But, you don't have to say, let's say not him, but, if the phone fell off your lap, well, you can say that, but you don't have to say, I was talking to my girlfriend, not my wife. You don't have to add, if you're on the phone with anybody, just basically taking responsibility, I think is a good move because liability is going to be clear anyway. So it's not, you're listening to this show, that's a fact. And ultimately, if he's at fault, that's going to be basically borne out. Now, if it's a matter of who had the red or the green light and he wasn't sure, don't take responsibility if you're not sure. But if you drop your phone and you swerved into oncoming traffic, that's provable. And then for the person that he hit, it's going to be a matter of damages. Doesn't look like he was in the course and scope of his employment. He was coming from a chiropractic visit. So the 49ers would bear no responsibility for what's called respondeat superior. It's just going to be straight up against Kyle Shanahan. Hopefully he's smart and he's got lots of insurance because he's probably got lots of assets, and hopefully he does.
I would be surprised if he didn't, but insurance follows the vehicle first, then it would revolve back to the driver and then possibly the company. But in this instance, and because he talked about a cell phone, and everybody knows you're not supposed to use a cell phone when you're actually driving a vehicle in any way, shape, or form. It's Vehicle Code Section 23123, and the code section says you have to actually be using it. Holding it and dropping it is not a violation of that code as long as it's not in use at the time. So it wouldn't appear that he violated any laws other than driving into traffic.
Yeah, so driving unsafe speed for conditions and then making an illegal a lane change. Ultimately, it's reasonable care, which is common law, which basically comes from English common law. And as Ed, as you would like to point out, as long as it's not repugnant, then we basically adopt that in the United States. The only place that we don't use British English common law is in Louisiana, French Napoleonic law.
Yeah, they're codified state. Sacre bleu.
Yeah. So, thank goodness for Napoleon because he was hard up for money, and that's how we got 1/3 of the United States for like $17 million.
Yeah, he gave us Louisiana and a stupid accent.
we got part of Canada too. We gave it back.
We all sound like Maurice Chevalier.
So the point is that he took responsibility right on. Yeah, reasonable care is the test. It is not reasonable to reach down to get your phone and go into oncoming traffic. Doesn't take Perry Mason to figure that one out. So it comes down to not about what happened. That's provable. He admitted it. It's about what damages the victim sustained as a result of what happened. And that comes down to excellent medical care. Because as we always say, it ain't about money. It's about your health. And happiness is attached to basically well-being. And well-being comes from the gift of good medical care. All right. River Cats, Dinger. It's a great name. Who knew that Dinger would actually become not a euphemism for hitting a home run, but basically taking somebody down on a scooter. It was a dinger. It was a stinger.
A stinger with a dinger.
And then Stomper, good thing it wasn't Stomper. That's the A's mascot. River Cats mascot crashed into Dodgers outfielder Alex Thomas in a scary collision. Alex Thomas had to appear in a Major League game for the Los Angeles since being traded from the Diamondbacks in May. The minor league hasn't exactly been treating the outfielder well, and I'm not even talking about his performance on the field. He has mascots on motorized scooters tormenting him, and that's a lot to worry about. Thomas playing for the Dodgers AAA affiliate, Oklahoma City Comets. He was leaving the dugout between innings in Sacramento on Saturday, and understandably, he didn't think to look both ways as if he was crossing the street. He really couldn't have expected to have the River Cats mascot Dinger barreling towards him on a scooter. And then they collided. He went to the ground, and they went 0 for 4. So bottom line, you don't assume the risk of that.
No.
Dinger's bottom line, man. I mean, I think Dinger's got the primary causative factor here because Dinger's got to be paying attention. I mean, you're basically a mascot. These guys are playing baseball. And, he does not have a reason. Because when you're coming out of a dugout, it's just like when you're pulling out of a parking lot. Your initial reaction is to look left because that's where traffic is coming from. And so you're not going to look right, especially not for a freaking anthropomorphized cat on a freaking scooter, right? And takes him down. So, if turns out he develops some symptoms like numbness, tingling, burning, or he's got a shoulder problem, he has an MRI, turns out he's got a discogenic problem, which ultimately needs a surgical intervention to correct the anatomical variation causing the symptoms, or a torn rotator cuff, and he's unable to continue on with his baseball career. Depending on how good he is and a good attorney, I mean, that's, you could basically argue that the diminution in earning capacity, it could be multi-millions of dollars.
Oh, possibly, but it would be speculative damages because he was already in the big leagues and then sent down to AAA. There's no guarantee that he would ever come back into the major leagues. So you're not allowed speculative damages in a claim. You have to actually have some hard evidence, more likely than not, that he was going to make it back up. Maybe he was on the way and Dinger knew it and just didn't want to take him out because they wanted to win, and he was the hitman in this instance.
Well, the way we do it is make sure he gets excellent medical care to, first of all, diagnostic testing, just like Aaron Rodgers, right off the bat, whatever symptoms you have in either joints or basically spine, and then depending on the findings, an extremity orthopedic surgeon or a spine surgeon. Then ultimately we get him to a voc rehab specialist and a forensic economist. We'll go from there. So if you want a local attorney, Mr. Thomas, we're happy to help. All right, when we come back, we'll talk about basically San Francisco threatens Apple and Google with the Notified app. And also, hey, if you want to get an EV, now's the time. Stay with us. When a person is seriously injured, there's no substitute for the personal legal relationship offered by the local NorCal firm of Ashton and Price. From the first attorney meeting, every important decision is made with a direct consultation with, and I can't believe I have to say this, a real, live, experienced, flesh and blood local attorney. It's called Home Court Advantage for a reason. Ashton and Price, serious local attorneys for serious people with serious injuries with no fee until we win. For the best local advice, don't think twice. Call Ashton and Price.
What happens when the direct nephew of George Washington matches legal wits with the most prominent shady attorney on the planet? I'll tell you, the All Things Legal Show. Decades of legal expertise distilling the latest sports and celebrity legal battles, the Constitution, AI, and the 1,000 ways Florida man flaunts the law while in flagrante. In the immortal words of the Princess Brides Vicini, Socrates, Plato, morons. Join Craig Ashton and Edward Shady on Spotify, TuneIn, Pandora, and Apple Podcasts, and listen to the All Things Legal Show anytime. You've been served.
Broke, busted, disgusted, agents can't be trusted, and then she wants to go to the sea. Cash can't make it, she says we'll have to fake it. We knew she'd come eventually. Greasing on American Express cars. But keeping out the heat. The distant vibrations in our imaginations can't go on indefinitely. And California dreaming is becoming a reality.
All right, that's brought to you by the G-Man. Born the same year as Don Julio, came up with 1942. But he doesn't act a day over 14, and ultimately he's as spry as way more than Bill Belichick, that's for sure. So about age is just a number with G, and a producer par excellence, old school radio. That's why if you like the show and you like the way it's produced, a lot of it has to do with the G-Man. All right, so essentially, they want to put a face to a voice. Go to AshtonandPrice.com or Ashton and Price LLP on Facebook. We are artisanal, curate cases from beginning to end, multi-million-dollar outcomes. As Polybius said, the first step is 50% of the outcome, and ultimately the first steps in our office are always curated by an attorney, and a lot of mistakes are basically avoided as a result of knowing where we need to go and what do we have to avoid, and you can't large language model, basically AI, your way into that one.
No.
And so, it's only can go so far, but when you're dealing with things that have massive consequence, like medical issues and legal issues, that very difficult to reverse and basically can cause long-term harm financially and physically, having a professional involved early is very, very important. And call us. You'll be super surprised. Talk to a lawyer when you call in. All right, so let's talk about Netflix first. So I think one of the reasons that Netflix may have kind of scrutinized some of the behavior is that you've got Paramount, Warner Brothers, Netflix are all basically looking to merge, and I think Paramount was looked to be bought by, or Paramount was looking to buy Warner Brothers, so it was Netflix. And so they look for contingent liabilities when they go in. They do a deep dive and go, okay, what problems do you have that we may have to factor into the purchase price, right? So we got this Netflix executive was fired from his $1.1 million a year job after revealing during a trust exercise at a work retreat that he had taken medically prescribed ketamine. A lawsuit is claimed. Kevin Bailey, who was vice president and head of creative at Eyeline Studios within the umbrella under the umbrella of Netflix, sued the company after it launched an investigation into his comments that ultimately ended in his firing. Bailey, who's been on the visual effects team for Pirates of the Caribbean, probably where he picked up the ketamine, maybe from
Johnny
Depp. Yeah, Johnny. And how can this go wrong? And the Harry Potter franchise says he took the drug under medical supervision, sought treatment for clinical depression during what is called a vulnerability exercise at a January 2026 retreat. It's kind of like, how people go, fall backwards and they don't catch the person. Well, this one, Instead of falling backwards, just metaphorically share with us your deepest, darkest secrets. At a January 26th retreat at the exclusive Sendero Ranch in Northern California property owned by Netflix, Bally shared with his colleagues that he had undergone that treatment, the suit says. He claims he explained the reason why he had taken the drug, but was investigated by Netflix anyway. And in March of 2026, a company investigator brought the incident up, quote, in a manner suggesting suspicion of recreational drug use. The executive was fired in April, so only a couple months after the trust retreat, with the company's attorney, so Netflix attorney confirming the ketamine therapy issue has factored into the termination. Bailey says in the lawsuit that basically used a lot of profanity and drank on the job. And he had been warned during his performance review that he should drop one or two less F-bombs, but not stop entirely. And then he says, hey, but everybody drinks at Netflix, and it's a bunch of drunks walking around. You know, the CEO's got a bar. He likes to, buy beers for people. And he's basically like Justice Kavanaugh. He loves beer.
Yeah, what's wrong with that? But, I mean, this guy was clinically depressed, and he had a good reason. I mean, he was depressed. It was as a result of his mother dying.
Yeah.
And so he went to get help, psychiatric help, and they were using ketamine off-label, meaning that ketamine wasn't designed necessarily for clinical depression. But if it is prescribed by a licensed doctor, even though it's off-label, it's completely legal to do that. So he didn't do anything illegal in any way, shape, or form that I could make out from this article. So throwing ketamine in there as the basis for part of the firing is absolutely, it's wrong, but it's not a protected class.
Yeah, it really comes down to what his contract says, because most of these high-level executives will have, you can only fire me for a cause, right? So the issue becomes whether or not the undisclosed ketamine therapy, in conjunction with the drunken profanity, which I think would be for cause.
Yeah, because it's contraindicated to use alcohol with ketamine.
Yeah, yeah. But the point is, if you got a great, a staff member, but every Friday she drinks and basically calls everybody, swears like a drunken sailor, probably for cause. I mean, you're great, but the drunken sailor behavior probably not what we're looking for in terms of the professional setting that we're trying to essentially put out as people that take over very complex legal issues for individuals that have suffered a significant injury. So the idea is that it's either wrongful termination, you basically took something privately from me that you forced me to basically disclose in a safe setting, a vulnerability trust exercise. And, trust, it says trust, it's in the label. And then I open up and then you fire me for that. Then basically that's an invasion, quasi-invasion of privacy. That's not for cause. That's a wrongful termination. Because he's not being terminated because he's a man, because he's Catholic, because he's basically, of a certain age. It's not a protected class. But what he's saying is that you essentially duped me into trusting you. And I gave you information that really isn't any big deal because, as you said, it's prescribed.
Yeah, it's off-label. And then, because they did it for cause, apparently under his contract, he would have had a severance package. And he specifically pointed out that he was denied 1 year of severance pay, which is $1.1 million that he got denied as a result of this, a little less than $100,000 a month, which is quite a bit of money.
Yeah, and one of the reasons you see these cases in the news and not other ones is that if somebody gets terminated, let's say this happens and they're making $1,000 a month, there's just not enough money to basically support the cost of litigation, because taking 7 or 8 or 10 depositions, the attorney's going to have to lay out probably $10,000 or $15,000 for that, and then the presentation of the evidence. So a plaintiff's lawyer is probably going to have to spend $20,000 to $40,000 to $50,000 to present a wrongful termination case with these facts. If you're not making this kind of money,
that's on the low end. It's a lot more than that.
Yeah. So the idea is that the cost-benefit analysis in everyday terminations that may have these facts never see the light of day because it's going to cost more or at least equal to what you would be receiving. In this case, there's enough money in controversy here that ultimately it probably would support a lawsuit, and that's why you see it.
Yeah, because California is an at-will state. It means you can be fired for any reason, for as long as it's not an illegal reason. But where you start getting into issues, is with a big company like Netflix, they're going to have a employee manual, and that employee manual is going to set out through human resources that, you're going to get a warning, you're going to get this, you're going to get this, and then it starts to become somewhat of a contractual issue. And when you start violating your company's own policies with regard to the termination, and that's when you start opening yourself up to the wrongful termination, not because it's a protected class. It's because you violated the quasi-contractual relationship that you've now set up voluntarily between you and your employee. Because when I first started practicing law, we hit lucky stores, luckily, a couple times, pretty good.
Yeah.
And our attorney I worked for that did wrongful termination.
And then slip and falls, you can't spell win without Winco.
That's right.
and Safeway is a misnomer. So it's a bloodbath in there sometimes. All right. So let's talk about what's going on with Google and Apple in San Francisco. So by and large, great companies. And, essentially California is the fourth largest economy in the world, primarily because we got Northrop Grumman. And it turns out they're coming out with a new airplane.
Nice.
Which is a fixed-wing plane that basically will have no windows. And because right now, Boeing used to be the leader, but now it's Airbus. And so it's a group that's based in California that's going to be working with Northrop Grumman in Southern California. And because it has no windows, they're going to basically put digital kind of windows, where you can pretend
like flat screen TVs?
But at first I thought that was kind of bad. But, flying to Europe, if you fly long distances now, you're really not by a window anyway. So, and then most of the times the window screens are down. So having like a digital recreation of what might be outside because there aren't any windows, and it allows, because it's fixed wing, it allows for like maybe 7 aisles or 8 aisles. I mean, it's going to be a bigger airplane. So the point is that California leads in a lot of things. So basically munitions and aircraft design, and also Silicon Valley. So we lead the world, and we are the fourth largest economy in the world for a reason, and a lot of it has to do with Apple and Google.
And it's timely that you brought that up, having a windowless plane, because was it last week in Europe, and Ryanair Airlines is like a discount flyer. It's EasyJet and Ryanair, both of them fly in Europe, and the window broke, and that guy got partially sucked out of the window during the flight.
Oh, yeah.
Yeah, so could you imagine, they yank you back in, sit you in your seat, put your safety belt on, and the guy goes, "Ooh, that was a close one.
Yeah.
I need a cocktail."
Yeah, right.
But now the guy actually got partially sucked out of the window. I think it was last week.
Well, the key word there is partially. So
Yeah,
thank
they
goodness
got
for
him
that.
back in.
Yeah.
But a windowless plane, that would not happen.
Yeah, no, it definitely wouldn't. So the idea is that that's just an aside to talk about our economy. So basically, we saw with a company called Backpage, which ultimately, usually the First Amendment is going to protect anything that's being published, and especially if it's commercial speech that you're basically just being a bulletin board like the internet. But because they were facilitating prostitution, then they were able to shut that down. So the idea is that in this particular case, the argument from the San Francisco District Attorney David Chu is that basically Google and Apple, so Google Play and then the Apple Store, allow for these apps called Nudify apps. So you can take a picture of somebody, even if you don't know them, get off the internet or wherever you get it, and then you can basically have that Nudify app take their clothes off, and then you can basically post it. Many people are using those to extort individuals, especially people in high school, and say, "Hey, I got a nude picture of you." They don't know if that really exists. And then, some kids have committed suicide as a result.
Well, if I got that picture and I had six-pack abs, I'd go ahead, put it out.
Yeah, right. Let me help you. But the point is that it is facilitating deep fakes without the subject's consent for profit by processing payment for unlawful images. So that's basically saying, look, you're monetizing, and apparently there's been 705 million downloads, and these two particular companies have made $117 million in extra revenue on this. So it's not a small figure. And so the idea is Apple and Google are profiting off apps that exploit women and girls by generating non-consensual intimate deep fakes. The district attorney for San Francisco said, while the companies cut ties with some problematic apps, Apple and Google have a responsibility to be proactive and vigilant to prevent sexual abuse. Bad actors are always looking for opportunities to profit off this technology, and new apps are popping up every day. So essentially what they're saying is, look, bottom line is you are the last piece of the puzzle, and you're monetizing this, so you have the most duty to make sure that you're not harming the public. And if you don't basically follow through, the next step is looking at civil penalties and maybe criminal charges.
Well, yeah, because revenge porn is a criminal act, and if the argument here would be that they're aiding and abetting in this, they're providing the material, and then the article also goes on. Following a report in April, said searches for these and the advertisements in the two stores that are online continue to steer users towards these apps. There's your abetting, and then they're aiding it with the company providing the services to the deepfake pornography operations may be presumed to have violated laws if received sufficient evidence that they're using these, say, for revenge porn. So you've got an aiding and abetting problem with regard to Google and Apple providing these apps for people to misuse.
Yeah, and the way that you get people's attention is that when you have youth, young girls and young boys that are victims of this, just like when we have with vaping, essentially have all of these flavors that are like watermelon, peppermint and all this stuff, essentially marketed, remember Joe Camel, marketed towards kids. And then at that point, we say, all right, health, safety, and welfare, police power, I think it's worth it. That's what happened with Google and Meta with that jury verdict that said, hey, these are young people with developing brains, and you have algorithms that are basically targeting them to get them hooked on these things. And whenever you have young people, like in this case, and now basically nude pictures of non-consenting adults and or children, then at that point, you have a pretty, you have an audience that's going to listen to you and say, all right, fine. We're all about liberty. We're all about basically pursuing happiness, but this is crossing over a line of self-interest that ultimately affects our children. And, perhaps something should be done about it. We should hold Apple and Google responsible.
Well, yeah, if you want something done about it, you have to take it to Capitol Hill, and they should do some legislation. So if anybody wanted some legislation done, start deep faking your legislatures, and they will look at it and say, oh, my God, I can't do that. I'm going to have to shut this down.
It's only a bill, man. All right, we come back. We'll go ahead and tell you about gas prices and EVs and ultimately some rebates. And then AI Judge Judy weighs down and breaks down stories about Florida man going crazy as only Florida man can. Stay with us.
A personal injury claim is not a lottery prize, and it is never a joke. Whether or not you've been injured in a slip and fall, pedestrian, bicycle, auto, Uber, Lyft, or big rig accident, you need serious, experienced local legal counsel. At Ashton & Price, we have successfully represented Northern California injury victims for over 25 years. The consultation is free, and there is never a fee until we win. And between you and me, we win a lot. So remember, for the best advice, don't think twice. Call Ashton & Price. What happens when the direct nephew of George Washington matches legal wits with the most prominent shady attorney on the planet? I'll tell you, the All Things Legal Show. Decades of legal expertise distilling the latest sports and celebrity legal battles, the Constitution, AI, and the 1,000 ways Florida man flaunts the law while in flagrante. In the immortal words of the Princess Brides Vicini, Socrates, Plato, morons. Join Craig Ashton and Edward Shady on Spotify, TuneIn, Pandora, and Apple Podcasts, and listen to the All Things Legal Show anytime. You've been served.
All right, we're back. When I say we're back, Craig Fontaine, Ashton, Edward Allen Shady. Yes, if it's in the game, it's in the game. A shady attorney giving some legal direction. One and only time in the history of the legal universe that makes sense. All right, want to put a face to a voice, go to ashtonandprice.com. All the multi-million-dollar resolutions in-house. $8.5 million, probably the largest personal injury settlement in the 21st century against the city of Sacramento. Ultimately working on probably going to be the largest slip and fall outcome for a Sacramento resident in history in the 21st century in the next 3 weeks. Probably $7 or $8 million outcome on that one. That's where it's trending just before trial. So the idea is that that's what we do for a living, not what we do on the show. All right, before we get into what you've all been waiting for, the AI Judge Judy weighing in on Florida man. Gas prices bumming you out. California will pay you to buy your first EV. So if it's not made or headquartered in California, $50,000 or less for a brand new EV, or they call it a ZEV, which means zero emission vehicle, which lumps in hydrogen, so it doesn't include hybrids, or $25,000 or less for a used vehicle. However, if it's headquartered like Rivian and Lucid is an amazing car, I'm telling you. I've had supercharged Range Rovers, I've had turbo Carreras, convertibles, I've had some pretty sweet cars just because, I've been practicing law for a long time, and you want your lawyer to be successful. So if I was driving a used Pinto, you'd probably go, well, maybe this doesn't know what
Might
he's doing.
blow up if you get rear-ended.
If the cars that I've been driving are any indicator of my ability as a lawyer, I'm pretty good at it. So the idea is that I know cars, and the Lucid is an amazing vehicle, and if you can get a lease return, so much the better. And unlimited, $1,750 for a used car, cash on the hood. So they give you the rebate right off the bat, or basically $3,500 for a brand new vehicle. And you should take a look at it, and that is an incentive. All right, let's go ahead and do AI Judge Judy. So this is Anthropic. So Claude, that's essentially their speaking anthropomorphic representation of Anthropic, which is called Claude. I type in right in the voice of Judge Judy, and this is what it gave me. Florida man caught driving lawnmower on highway, arrested for DUI. Mr. Burke, let me get this straight, because I want to make sure I have the facts correct. You're operating, and I use that word generously, a lawnmower on Highway 316. Posted speed limit is 55 miles an hour on a lawnmower that I'm confident does not go 55 miles an hour. Does it, sir? No, it does not. It tops out at 8 miles an hour if the grass is dry. And when the deputy, who, by the way, showed considerably more patience than I am currently showing, asked you to perform a field sobriety test, you didn't dance around it. You didn't make excuses. You looked him in the eye and said, and I'm quoting you now, just take me to jail. That, sir, is the most honest thing anyone has ever said in my courtroom in a decade. And I almost want to give you credit for it. Almost. But here's what I don't understand, Mr. Burke. 3 prior DUIs, license suspended 3 times, revoked 4 times. 4, at what point, and I want you to think about this, at what point did it occur to you that if you don't currently possess a valid license, the answer is, should I drive something? The answer is no, regardless of whether or not that something has a steering wheel, 4 wheels, or a grass-catching bag on the back. You didn't sneak out in a car because maybe some small flickering ember of judgment told you that was a bad idea. So you got creative. You thought, well, they can't stop me for driving without a license if I'm on a mower. Sir, this is not a loophole. This is not clever. This is the same crime propelled by a Briggs & Stratton engine of a V6 at 1/7 the speed and 100% the stupidity. You are drunk, unlicensed, and doing 8 miles an hour down the middle of a state highway like you're leading a parade nobody asked for. Bailiff, take his mower keys, both of them. I don't care that a mower doesn't have keys. Find something to confiscate. Case closed.
Nice. Oh, here we go. One Florida woman, movable Walmart feast, muffins, sushi, rotisserie chicken, washed down with a fine Chianti without fava beans. All right. So, Judge Judy, let me make sure I understand the sequence of events here, because I want it on the record. You get into a Walmart store's motorized cart, the ones designed, mind you, for people with mobility issues, not for people who intend to conduct a rolling picnic, and you proceed to eat your way through the store like it's a rolling buffet on wheels. Sushi, a piece, back in the box. Back on the shelf, cinnamon rolls, mini muffins, and then, this is the part that really gets me, majority of a rotisserie chicken. Not a bite, not a taste, the majority. Miss Lopez, that is a meal. That is dinner. You had dinner at Walmart on a scooter with a side of wine, and you didn't even have the decency to use a plate. And the wine, a half-empty bottle sitting right there in your cart in plain view, like you were just going to wash down the chicken all day long with the wine on Tuesday. Now, when the loss prevention gentleman finally catches up to you and asks why you did it, you tell him you were hungry and didn't want to bring the food outside the store. I wanted to sit with the answer for a moment because I've sat with it. And what tells me is that somewhere in your mind, there was a rule, an actual rule, that said, eating stolen food inside the store is fine, but taking it out into the parking lot, that would be stealing. Walmart does not have an honor system with consumption on premises where it is complimentary. So let's review. A joyride on a mobility scooter, followed by an all-you-can-eat tour of the deli and bakery aisle, followed by wine in Walmart in broad daylight with a straight face when confronted. You told the detectives you knew it was wrong. Good. That's the first correct thing that's happened to you in the store all day long. Hold on to that thought, though, and maybe put it to use next time before you eat the chicken and drink the wine. Case closed. Somebody get this woman a sandwich and make her pay for it.
All right, here we go. Last one. AI Judge Judy. Claude's Anthropic writing a Florida man story in the voice of Judge Judy. Naked man with sex toys gets address wrong. Ooh. Enters stranger's home. Sir, let me see if I can piece together your evening, because I have questions, and I suspect you do too in hindsight. You had apparently a plan, a rendezvous. Somebody was expecting you, clothed or otherwise, at a specific address, and you had, by your own admission, come prepared. Prepared, sir, is an understatement. You brought a bag, a whole bag of adult toys. This is not a spontaneous decision. There was shopping involved. There was packing involved. There was at some point a person standing in the bedroom thinking, do I need all of these or just some of these? And the answer apparently was all of them. And then, with all that preparation, all that planning, all that bag packing, you arrived at the wrong house. Not almost the right house. Not next door. The wrong house. Empty-handed of clothing, fully handed of accessories, you let yourself into a residence belonging to someone who had no idea you existed. No invitation extended, and most certainly no interest in your bag. So I want you to think about the homeowner for a moment. It's an ordinary day. Maybe they're watching television. Maybe they're doing the dishes. And suddenly a naked stranger standing in their home carrying a duffel bag of intimate equipment like he's here for a delivery nobody ordered. That's not a mix-up, sir. That's a home invasion. Very, very specific and very unfortunate wardrobe malfunction. Now, I understand the address can be confusing. Numbers get transposed, apps glitch. Streets have similar names. I have sympathy for that in the abstract. What I do not have sympathy for is the fact that at no point during this excursion, not when you pulled up, not when you got out of the car, not when you walked to the door, not when you opened it and walked inside the house, naked, did you know it was not yours? And did anything about the situation give you pause? No lights seemed unfamiliar? No furniture that seemed off? No little voice saying, is this definitely the place? You are so committed to the plan that you executed it flawlessly at entirely the wrong location in front of entirely the wrong person. Sir, I don't need to know what was in the bag. I don't want to know what was in the bag. What I need you to understand is that GPS pins exist for a reason. And next time, and Lord willing, there will not be a next time, you confirm the address before you confirm anything else. Case closed. And somebody hand this man a robe.
No
So, yeah, that's Judge Judy. Essentially, it's amazing putting that in, and literally within, maybe 15 seconds, it pops out exactly that response, which is funny. And, sometimes the law is a little bit off. So obviously you do not want to use this if you're in an auto accident, you've got basically some issues regarding trespass, and you're thinking about suing your neighbor, you got a dog bite. Using Claude or OpenAI or any of those, or even Gemini, it can give you basically some direction, but it can lead you in the wrong direction like this guy. And instead of being naked in somebody's house with a bag of sex toys, you're going to end up with a case that's basically irretrievably in the wrong direction, and you won't get justice. All right? Hopefully you enjoyed the show. We enjoyed doing it. For the best advice, don't think twice. Call Ashton and Price.
You've been listening to the All Things Legal Show with your host, Craig Ashton. For more information, go to ashtonandprice.com or call 916-786-7787. Go to Apple Podcast and download the show if you missed it. Remember, for the best advice, don't think twice. Call Ashton and Price.